First of all, there is an addendum report or addendum allegation that specifically that allegation has to do with Butler County Case 25 CR 161, where Mr. Fisher has entered a plea of guilty to possession of fentanyl. And that happened during a time when he was on probation in this case. He does stipulate to that and does have sentencing coming up on that. Further, he does stipulate that he has not paid fines, costs, and fees. He does stipulate that he has not provided proof of employment to his ISO. He further stipulates that on 2 other occasions, he did not report to the ISO police contact within 48 hours. Those are the stipulations he is making at this time, Judge.
All right, buckle up because this case is already heating up. We're looking at the state of Kansas versus Dustin Pfizer, and right from the start, we see a defendant who's juggling multiple probation violations, a pending felony case, and a family at home. The courtroom is tense as the attorneys lay out a complex web of stipulations, from unpaid fines to missed probation reporting and a guilty plea for fentanyl possession. Right here, the stage is set. Will the court show leniency, or is Dustin about to face serious consequences? Stick around because we're about to break down every shocking moment, every contradiction, and what this could mean for him and his family.
Mr. Regier, is the state willing to drop the other allegations and accept the stipulation?
Your Honor, it would appear that on the record, counsel for the defense has indicated the defendant will stipulate to the violation in the addendum as well as not paying fines, costs, fees, not providing proof of employment to the ISO, and not reporting police contact. The state has no objection to proceeding on those stipulations alone.
Your Honor.
Just a moment, Mr. Williams, or Mr. Fisher. I'll be right with you.
Yes.
All right. Okay, Mr. Fisher, the attorneys have told me that you're stipulating or agreeing that you violated the terms of your probation for the things that they mentioned. Is that correct?
Yes, Your Honor. For the not reporting the probation or to my probation officer that I had police contact, I didn't have a
okay. Hold on a minute. I'm going to give you an opportunity to tell me mitigating factors later on before I've announced my decision. Right now, I've got a few questions to be sure
yes, Your Honor.
What you're doing. Mr. Fisher, do you understand that you have a right to a hearing where the state would have to show by probable cause that you no, a preponderance of the evidence. I'm sorry. Preponderance of the evidence that you violated these terms of your probation?
Yes, Your Honor.
I didn't. Basically, the state would have a hearing where would prove to me that you made these violations. So you understand you have a right to that hearing?
Yes, Your Honor. And
you understand that with a stipulation, you're agreeing to those violations and the court can sentence you. It looks like when you were sentenced in May of 24, Judge Webster gave you was it Judge Webster? Yes. Sentenced you to 8 months with a $200 fine. You understand?
Now, pay close attention. Dustin is stipulating to multiple probation violations, missed reporting, unpaid fines, and police contacts he failed to disclose. What's interesting here is the sheer pattern of repeated offenses. The judge is meticulously walking him through his rights, ensuring he understands that by stipulating, he's waiving the right to a full hearing. This is critical because it frames the stakes. Dustin is voluntarily admitting violations, which could accelerate serious consequences. And here's a note for viewers: stipulations like this aren't just formalities. They are legally binding agreements that can make or break someone's freedom in a matter of minutes.
And that with your stipulation, you'd be waiving that right to that hearing and you could be ordered to serve the remainder part of that sentence.
Yes, Your Honor.
Very well. Has anybody forced or coerced you in some fashion to make these stipulations?
No, Your Honor.
Have you had sufficient time to discuss this with Mr. Patterson?
Yeah.
All right. I do find that the plea or that the waiver hearing is knowingly and voluntarily entered with the advice of good counsel that there is, and I do find he's violated the terms of his probation as stated in those. The other allegations are dropped. And I will hear recommendations of the parties, starting with the state, then Mr. Patterson, and then finally Mr. Fisher himself. So, Mr. Regier, recommendations?
One moment, Your Honor. Your Honor, this appears to be the second request for revocation in this matter. The state's information is that previously a journal entry of probation violation was filed with the court. It would appear that this came before hearing back in June, where the court did where the court found that the defense stipulated to a number of violations. At that time, the court did order that the defendant serve a 48-hour sanction and that and then return to reporting probation for a period of 6 months. In light of it would also appear that the first hearing on the request for revocation currently before the court occurred approximately 1 month prior to today's date, and within approximately 3 to 4 months of the last request for revocation of probation was concerned. With all that being said, the state is recommending that the court pursue outright revocation, that the defendant be ordered to serve his sentence.
Very well. Mr. Patterson?
Judge, I am going to bifurcate the defense's request in this case and have basically two different requests for the court to consider. First one is a request for the court to continue the disposition in this case. The reason behind that request, Your Honor, is as stated and stipulated to by Mr. Fisher. He has a felony case set before Judge Rickey that is...
Let's rewind a bit. The court dives into Dustin's history, and it's not looking good. There's a prior revocation from June where he served 48 hours and had to follow strict probation reporting for 6 months. And now, just a few months later, here we are again. The court isn't just looking at one slip-up, it's a pattern of repeated non-compliance. For anyone watching, this is where the drama intensifies. The judge must balance fairness with accountability, and Dustin's repeated lapses make leniency a tough sell. You can feel the tension in the room. Every pause, every hesitation matters.
Amended information, 1 count, possession of fentanyl, level 5 drug felony. It's believed it's going to be Senate Bill 123 case. That case is set for sentencing on December 5th at 1 o'clock in front of Judge Rickey. Judge, there's a request by the defense to continue this to some date after that sentencing to determine what happens on his felony case, which could be information to be used to determine how long he should be in jail, Judge. If you think about Senate Bill 123, it's an 18-month probation with requirements they get treatment and enter into treatment. That 8 months in jail first might severely interfere with his ability to become clean and a good community member. So we'd ask the court to, first of all, continue disposition. If the court elects not to continue disposition, Judge, we would ask the court to order a sanction and reinstate probation. The violations as listed, Judge, that he had 2 occasions of police contact, one in July and one in September 7, and that he had not reported that till September 19, according to this report. My client has told me he had some communication phone issues, that he reported those when he got into his probation officer. He still tells me he is currently employed and can provide some proof of that.
Here's where the defense throws a Hail Mary, requesting a continuance so Dustin can sort out his felony sentencing and keep his probation intact. They're arguing that an immediate jail sentence could disrupt treatment and harm his family life. But notice how the judge listens, weighing these mitigating factors against Dustin's history. It's a classic courtroom tug-of-war, empathy versus responsibility. And for our viewers, think about this. Is it fair to delay consequences for someone who repeatedly violates probation, or does this show the system trying to rehabilitate rather than just punish? Comment below with your take.
Judge, he is also, he has a wife at home or significant other, a child at home. He is helping to raise. So a significant amount of time in the jail would probably hurt the entire family, Judge. So we are asking the court for a sanction, reinstate, or to continue this till after his felony sentencing. Thank you.
I'm going to deny the request for continuance, and I will make my decision today concerning revocation. So that request is denied. Mr. Fisher, is there anything you would like to advise me before I announce my decision?
Yes, Your Honor. I have obtained employment. I've been working with my brother-in-law. He has a plumbing business. It's the Real McCoy. And I've also been doing like, it's a side job, but it's scrapping metal with this guy that contracts through, I think I want to say Simmons Well Service. And like I have been working. That's what I'm trying to say. And I'm not trying to waive my responsibilities to what has took place. I know that with everything that at hand, I mean, there's certain circumstances that have hindered me from having successful, getting things done in an orderly time and doing things like in the fashion you guys want me to do them. There's a lot of factors in there that, I mean, are out of my control. And I mean, I'm not trying to deter my responsibility to the situation. Things have been rough. Let's say that. That's all I have to say.
Thank you.
Mm-hmm.
In reviewing your...
Now Dustin speaks up, giving the court details about his recent employment and personal struggles. He mentions working for his brother-in-law's plumbing business and doing side gigs, painting a picture of someone trying to get back on track. But he also admits that circumstances out of his control have hindered his compliance. This is the human element. Viewers can see the emotional strain, the tension between trying to fulfill obligations and being weighed down by past mistakes. It's raw, it's real, and it's exactly what makes courtroom footage so compelling. The balance of accountability and understanding.
File, as noted, you on June the 16th, there was a revocation hearing. On that date, Judge Webster placed you, gave you a 48-hour consequence.
Yeah.
And okay, you don't need to respond every time I pause.
Sorry. Sorry, Your Honor.
You had numerous violations, including that you were unsuccessfully discharged from alcohol and drug counseling in February of 25, admitted to drinking alcohol, did not provide proof of employment, many of the same sort of behaviors that we're here today. In fact, here we are in October, and the motion to revoke was October, and we're here in November. I note that your offense was driving while an habitual violator, first conviction. to get a habitual violator, you have to have at minimum, three major violations on your driving history. And now you additionally have possession of fentanyl. I have, for the last 5 years, been hearing juvenile and, more importantly, not the care and treatment, but the cases concerning children. And when children's parental rights, I have had to officiate where children have watched their parents die, found their parents' bodies where they've overdosed from fentanyl. Watched two of them that watched Narcan bring a